Welcome back to our channel, the place where hidden chapters, royal secrets, and the stories the palace won't publish finally come to light. Today, we bring you a breaking news: Harry's 15-month trial in chaos. Witness bails, Meghan loses it. A significant legal lawsuit initiated by Prince Harry, the Duke of Sussex, alongside other prominent public figures against the publisher of the Daily Mail, has encountered a potentially critical hurdle. A witness whose 2021 statement was a crucial piece of evidence for the claims has now officially retracted that declaration, claiming it was fabricated and created without his agreement. This reversal jeopardizes a crucial aspect of the lawsuit alleging systematic illegal information collection by Associated Newspapers Limited (ANL) and alters the dynamics of what was anticipated to be a landmark trial. The development increases financial and reputational risks for all parties involved as they prepare for a high court case anticipated to draw significant public and judicial scrutiny. The lawsuit was initiated in October 2022 by a group of 7 plaintiffs, including the Duke of Sussex, Sir Elton John, and his spouse David Furnish, actress Elizabeth Hurley, actress Sadie Frost, and Baroness Doreen Lawrence, mother of Stephen Lawrence. ANL, the publisher of the Daily Mail, the Mail on Sunday, and the Mail Online website, is accused of participating in or commissioning illegal activities to acquire private information over an extended period from 1993 to 2011, with some purported activities reportedly persisting intermittently until 2018. The allegations revolve around a series of invasive practices that, if substantiated, would constitute significant violations of privacy law and may involve criminal activity by third parties, along with possible legal liabilities for the publisher. ANL has persistently and emphatically refuted the charges, characterizing them as preposterous smears and contending that several claims are time-barred due to the elapsed years since the purported events occurred. The publisher emphasizes that established editorial and legal compliance procedures have been implemented and continue to exist to avert illicit news gathering. The purported actions described by the claimants are broad in range and varied in approach. The allegations include the employment of private investigators to install listening devices in vehicles and residences, the covert recording of private telephone conversations, the incentivization of police officers to reveal confidential information, the impersonation of individuals to acquire medical records, and the illicit access to bank accounts or financial transaction data. Each category of allegation presents distinct factual and legal inquiries. For instance, the installation of surveillance devices entails physical trespass and covert observation, potentially invoking torts, such as trespass to the person or property and misuse of private information. The recording of telephone conversations engages interception statutes and data protection regulations. The remuneration of police officers for sensitive information implicates corruption, possible criminality, and violations of duty by public officials, whereas impersonation to acquire medical records involves both data protection safeguards and confidentiality obligations owed by healthcare providers. ANL's defense has been to dispute the veracity of those accounts, to question the origin of the evidence presented by the claimants, and to assert that most historical grievances are beyond the statute of limitations for judicial remedy, invoking limitation grounds and contesting causality and attribution. The core of the claimants' argument was a 2021 witness statement from Gavin Burrows, a private investigator linked to numerous media-related inquiries in the past. The document was submitted as an acknowledgement by Mr. Burrows of his involvement in illicit information gathering activities for ANL newspapers, including operations aimed against Prince Harry and other public people. If authentic and permissible, such a statement would offer direct testimonial evidence connecting the publisher to the alleged practices in the litigation, thereby enhancing the claimant's capacity to demonstrate a pattern of conduct by ANL during the relevant periods. In litigation aimed at illustrating systemic practices spanning decades, testimony from former investigators detailing methodologies, the identities of intermediary actors, and the mechanics of information flows is particularly valuable as it can integrate disparate documentary and circumstantial evidence into a cohesive narrative. In a significant turnaround, Mr. Burrows has submitted a new comprehensive witness statement to the High Court in which he withdraws his previous account. Multiple national newspapers have reported that Mr. Burrows contends the 2021 document was not authored by him. He argues it was created by others sent to him for his signature and that the signature on the document is not his. In his recent declaration, he is cited as characterizing the prior statement as a complete fabrication and a forgery. These allegations are unequivocal and entail ramifications not only for the claimant's case, but also for any ensuing investigations into the construction of the litigation, the intermediaries between investigators and attorneys, and the adequacy of the procedures for validating witness statements. A retraction of this nature compels the court and the parties to scrutinize chain of custody concerns regarding witness materials and to assess the existence of any documentary endorsements, recordings, or corroborative materials to verify the origin of the prior statement. This retraction profoundly changes the evidence framework. A witness anticipated to deliver direct testimony has at least formally become a figure whose reliability is contested. His motivations and the context of his utterances will now undergo rigorous judicial and public scrutiny. The claimant group's legal representatives have recognized the updated stance and have stated that they will not summon Mr. Burrows to provide live testimony at the trial. The claimants assert that they will depend on other materials, including what is characterized as hearsay evidence narratives regarding statements Mr. Burrows purportedly made to third parties concerning his alleged admissions. Hearsay inherently comprises second-hand information. A witness recounts what another individual purportedly stated, rather than providing a direct account of events they personally observed. In numerous legal systems, including the civil courts of England and Wales, hearsay may be permissible when the original declarant is unable or unwilling to testify. However, it is generally given less evidentiary weight than direct oral testimony from the individual who allegedly made the statement, primarily because it precludes the opposing party from cross-examining the original speaker regarding their claims and credibility. The dependence on hearsay in lieu of direct witness testimony presents tactical drawbacks. Cross-examination is the primary technique for assessing credibility and accuracy in adversarial trials. It enables a side to investigate inconsistencies, evaluate memories, contest intentions, and reveal potential collaboration or enticement. In the absence of Mr. Burrows' testimony, the claimants must convince the judge, relying on second-hand accounts and documentary evidence, that the original 2021 statement's contents are sufficiently reliable and probative to substantiate their claims. The lack of a main witness available for direct interrogation renders the evidence of previous clandestine misconduct inherently more challenging to establish. Judges evaluating hearsay evidence will determine its cogency and the justification for its admission and reliance. However, the intrinsic constraints on credibility assessment necessitate that hearsay is frequently substantiated by corroborative material to possess the requisite weight for establishing disputed factual claims on the balance of probabilities. Mr. Burrows' recent response complicates the situation by not only denying the allegations, but also presenting specific complaints regarding the manner of his recruitment to furnish material initially. He has identified particular persons whom he claims coerced him into joining the lawsuit against ANL, including Graham Johnson, a former journalist with a previous conviction related to phone hacking, and Dan Waddell, a paralegal employed by the claimant's law company, Gunnar Cook. In the recent petition, Mr. Burrows claims he was enticed by assurances of considerable financial compensation, allegedly a monthly retainer of $5,000, about $6,300, to collaborate with the case. He recounts being informed that aiding in the litigation would be financially rewarding, characterizing the arrangement as a perfect scam and a gravy train, based on the idea that media conglomerates often opt to settle disputes to evade the costs and negative publicity linked to extended trials. If the court accepts those allegations or they are substantiated at a preliminary hearing, it would not only cast doubt on the credibility of Mr. Burrows' prior testimony, but could also initiate disciplinary or professional investigations into the actions of intermediaries and legal personnel engaged in the litigation process. If the court acknowledges Mr. Burroughs's assertion that he was actively solicited and financially motivated to furnish evidence he now claims was falsified, such allegations would not only undermine the credibility of the 2021 statement, but could also challenge the methodologies employed in acquiring some of the claimant's other evidence. The ethical and procedural regulations in litigation regarding disclosure requirements and the behavior of legal representatives and their agents aim to avert the fabrication or unjust manipulation of evidence. Accusations that investigators or intermediaries paid or delivered incentives to get testimony, particularly testimony that claims to acknowledge misconduct by third parties, raise apprehensions over inducement and the possible tainting of the evidential record. The claimant's attorneys have, as of the latest reports, not provided a comprehensive public response to the specific allegations against the individuals identified by Mr. Burroughs. However, they will be required in court to elucidate sourcing chains, disclosure protocols, and fees disbursed to third parties involved in case preparation. A&L's legal staff has capitalized on the news and indicated its intention to mount a robust defense. The publisher has explicitly stated its intention to subject the plaintiff's claims to thorough examination and has shown a readiness to cross-examine Prince Harry if he chooses to testify. The recantation for A&L contradicts a crucial piece of primary evidence used to illustrate systemic or commissioned illegality and provides a chance to recontextualize the litigation as based on unreliable testimony and potentially opportunistic claims. The persuasiveness of the recharacterization to the court will hinge on the comprehensive evidence the claimants can provide, including documentary records, communications between journalists and sources, bank records or invoices indicating payments to intermediaries, correspondence linking investigators to editorial directives, and corroborative witness statements from other former investigators or insiders. In the absence of a definitive paper trail demonstrating purported conspiracy or clandestine actions from decades before necessitates the compilation of disparate data into a narrative that satisfies the civil standard of proof. The financial consequences of the failure of a crucial witness statement are significant. Litigation before the High Court of England and Wales is costly, particularly when the disputes are intricate and include numerous parties, considerable disclosure, and comprehensive expert and factual evidence. The trial is projected to last roughly 9 weeks with total legal expenses for both parties anticipated at over $24 million, nearly $30 million. The figures reflect the extensive resources that will be mobilized during the proceedings: witness preparation, comprehensive document disclosure and review, forensic analyses, legal argumentation and advocacy over several days in court, and the involvement of top-tier counsel, all culminating in a significant expense. In instances requiring technical or specialized evidence, such as forensic analysis of allegedly intercepted conversations, digital forensics handwriting, or signature examination or account tracing, supplementary expert fees and extensive reports contribute to the overall cost. According to the dominant civil litigation rule known as the loser pays concept, the unsuccessful party in English civil proceedings is typically liable for a significant share of the successful side's recovered legal expenses. If the claimant's case were to fail, they could anticipate being required to contribute potentially a substantial amount towards A&L's legal expenditures, in addition to covering their own. The exact distribution of expenses is to be determined by the trial judge, considering considerations such as the behavior of the parties' settlement proposals made during litigation, the reasonableness of certain professional fees, and the likelihood of success of certain claims. Commentary accompanying the filings indicates that Prince Harry's potential liability in the event of an adverse costs order could range from $4 million to $5 million, approximately $5 million to $3 million, although the final amount will be contingent upon the judge's evaluation and any distribution among the various claimants. Claimants frequently pursue insurance or third-party funding to cover such risks, and attorneys may engage in negotiations with insurers or funders to reduce personal liability. However, these arrangements generally entail commercial factors and do not eradicate the reputational repercussions of an unfavorable outcome. These prospective financial obligations arise among other expensive legal pursuits undertaken by the Duke of Sussex. In January 2024, Charles retracted a libel claim against the Mail on Sunday for a piece about the security measures afforded to him after he relinquished his top royal duties. The withdrawal transpired just prior to a deadline for the submission of specific documents, resulting in his liability for the newspaper's legal expenses, which are estimated to be over $750,000, almost $1 million. He is involved in legal proceedings with the Home Office regarding the revocation of his claim to automatic publicly paid police protection while in the United Kingdom. In February 2024, the High Court determined that the government's decision was lawful and rational. His initial appeal effort was failed, but he has requested additional authorization to appeal directly. The issue has incurred legal expenses, allegedly beyond $1 million. In contrast, the Duke has attained some litigation victories, including a 2023 High Court decision, acknowledging that he was a victim of illicit phone hacking by Mirror Group newspapers MGN. Collectively, these instances illustrate a trend of legal activity that has yielded inconsistent outcomes and considerable costs, becoming a prominent aspect of his public life. The current lawsuit against A&L may thus signify the most significant of Prince Harry's legal problems to date, both in terms of legal implications and reputation. Should the claim collapse or significantly weaken at trial, especially if the court determines that essential evidence was manufactured or improperly influenced, the reputational harm might be considerable. A judicial ruling unfavorable to the plaintiffs on this matter would probably be exploited by detractors who contend that the Duke's fight against certain factions of the British press is driven by personal animosity rather than a fundamental commitment to media standards. If the claimants prevail based on their remaining evidence, the ruling would bolster arguments regarding reckless press conduct and illegal intrusion, potentially impacting the broader discourse on media regulation and the legal safeguards afforded to public figures and private individuals. A successful claim may result in damages awards declarations regarding unlawful activity and may be injunctive remedies to avert future exploitation of private information. It could also bolster demands for reform in the interactions between media organizations and third-party investigators and sources. The disagreement extends beyond the immediate litigants, influencing broader considerations regarding the relationship between the monarchy and the media in contemporary United Kingdom. The royal household has traditionally followed an unwritten principle encapsulated as never complain, never explain, a stance aimed at maintaining the institution's dignity and distancing it from the mundane conflicts of public life. The plan aimed to insulate the monarchy from public controversy and to ensure the royal family remained a unifying rather than a polarizing entity. Prince Harry's consistent readiness to pursue legal action and publicly address press conduct signifies a notable shift from established norms. It has revealed fractures within the family and subjected the royal household, along with its rapport with the press, to increased strain. The tension arises not merely from personal conflict, but from institutional factors. The monarchy depends on the media to disseminate its activities and sustain public attention, and enduring hostility threatens to complicate that relationship. Insiders associated with the royal household have allegedly conveyed unease at the contentious and public character of the Duke's legal disputes. King Charles III and Prince William, the Prince of Wales, are reportedly apprehensive about the potential for prolonged, high-profile legal disputes with prominent media entities, partly due to the sustained scrutiny these conflicts attract regarding familial discord and the risk of disrupting the historically established, yet fragile equilibrium in relations with the press. The media serves as the primary channel via which the public acquires knowledge about the royal family's functions and personal endeavors. Interactions with journalists and editorial choices significantly shape the people's daily impression of the monarchy. Some individuals, both within and outside royal circles, contend that a prolonged conflict with national newspapers could inflict enduring harm on the institution's ability to communicate and preserve public support. For an institution whose soft power is significantly dependent on public regard and media influence, an extended public legal dispute constitutes a strategic and reputational risk. Prince William, poised for ascension to the throne, perceives his brother's legal disputes and public revelations as a distraction that may hinder his endeavors to foster a solid and consistent image in anticipation of his future rule. The difficulties revealed in Prince Harry's memoir, Spare, and subsequent media appearances have publicly highlighted aspects of familial discord. Ongoing litigation that attracts additional media attention perpetuates the emphasis on domestic conflicts rather than the monarchy's public responsibilities. These issues extend beyond private concerns. The perception of royal interactions with the media possesses constitutional and civic implications in a nation where public opinion toward the monarchy is a crucial factor in the institution's legitimacy. The royal family's collective approach to conflicts with prominent media organizations may impact the maintenance of authority, public trust, and the unwritten norms that have regulated press access for decades. Simultaneously with the legal proceedings, the Sussexes' public image and brand management are under rigorous examination. A recent incident concerning their presence at Kris Jenner's 70th birthday celebration at Jeff Bezos's Beverly Hills residence emerged as a minor flashpoint. Kim Kardashian shared photographs of Prince Harry and Meghan, the Duchess of Sussex, on Instagram, which were then withdrawn. This sequence of posting and deletion sparked speculation and conflicting narratives in celebrity media over the rationale for the removal. A tweet from the gossip account, Du Moi, indicated that the photographs were removed because the Duchess was not adorned with a red remembrance poppy, a sign commonly recognized in the United Kingdom to honor deceased service members. The poppy holds significant cultural importance in the UK and Commonwealth nations. For royal family members, especially those with a strong connection to military service like Prince Harry, donning the poppy during the remembrance period is considered a profound gesture. A columnist provided an alternative explanation, stating that the Sussexes requested the removal of the photographs due to their publication without prior consent. This narrative portrayed the action as aligned with a meticulously orchestrated public relations strategy aimed at regulating the timing and manner of image and detail dissemination. Regardless of the accuracy of those specific reasons, the incident exemplifies the level of scrutiny directed onto relatively trivial public engagements by the Duke and Duchess, as well as the significant interest in symbolism and message management. This also illustrates a wider conflict in contemporary celebrity and public existence, the interaction between being a public figure subject to examination and the aspiration to curate one's image within a media landscape that merges conventional outlets with influential social media platforms and networks of influencers. For individuals such as the Sussexes, who possess a multifaceted relationship with both traditional media and contemporary internet platforms, each public appearance can elicit numerous storylines, interpretations, and repercussions. In a context where snippets and photos disseminate globally, instantaneously, reputational hazards and the necessity for swift, occasionally defensive communication methods are intensified. Mr. Burroughs's recantation signifies more than a mere evidential setback for a single case. It possesses the potential to alter public perceptions regarding the legitimacy and actions of a prominent campaign against a major media organization. The claimant's legal team will be responsible for reconstructing an evidential case independent of their former star witness. They must compile documentary records, corroborative witness testimony, and any other admissible materials that can substantiate the purported patterns of unlawful behavior over the pertinent decades. This is a challenging endeavor concerning historical events, especially when covert activities are claimed and contemporaneous documents may be limited, deliberately obliterated, or disputed. The claimants may utilize other former investigators, whistleblowers, internal editorial documentation, billing data, and emails that illustrate editorial directives or payment trends pertinent to their case. For A&L and its advocates, The recent revelation presents a chance to argue that the claimant's fundamental assertions are untrustworthy, or at the very least inadequately substantiated, warranting the case's dismissal in whole or in part. The court's responsibility will be to evaluate conflicting accounts of events, assess witness credibility, and document authenticity, and apply established legal principles regarding admissibility, weight, and causation to ascertain if unlawful conduct occurred and if the publisher is liable. The judge must reconcile the challenges of substantiating historical covert misconduct with the necessity of upholding stringent criteria for the admission and reliance on disputed evidence, which includes examining potential motives for fabrication or inducement and assessing the appropriate weight of hearsay and circumstantial evidence. The previously simple tale of public figures pursuing responsibility from a dominant newspaper publisher has become significantly more intricate. The retraction by a once pivotal witness prompts critical inquiries regarding the formulation of the claim and the viability of sustaining important evidence in his absence. This increases the immediate financial stakes for the claimants and guarantees that the forthcoming 9-week trial will address both the purported historical actions of Fleet Street and the current integrity of the litigation. The outcome will impact not only the involved parties, but also the ongoing discussions regarding press conduct, the legal recourse for those alleging grievances, and the overarching dynamics between public figures, the media, and the institutions that facilitate their interactions. As the legal teams ready themselves for a meeting at the Royal Courts of Justice, the future of Prince Harry's campaign against some segments of the British media suddenly seems uncertain and contentious on various fronts, with substantial legal, financial, and reputational ramifications at stake. Thank you for watching the video. Please let us know your thoughts, and goodbye for the time being.